I want to leave some time for questions, but before I do that, I want to just go back through the group here and give you just 2 or 3 minutes if you'd like to respond to anything that has been said thus far. And we'll start with you, Terry.
No, I think all the presentations were comprehensive and fit together nicely. I'd rather just get to questions. I'm good, thanks.
Jonathan?
Yeah, I just have one quick clarification point on the Osorio case. As Linda mentioned, it's part of this larger piece of litigation, or pieces of litigation, some of which have been brought originally in the United States, and that's the Mejia case that I was referring to in terms of the shenanigans and the fraud findings with Judge Cheney. Osorio was an enforcement of judgment case that was semi-shenanigans, I guess, with a local law, a hostile local law being enacted, Law 364, and the court didn't consider the fraud issues that Judge Cheney found, but I just wanted to put that in just a little bit of context.
Okay. Linda?
No, I think it would be, helpful to have questions at this point.
Okay.
David's already heard me on the state-federal issue, so I don't think anyone else wants to hear me again.
I'd like to throw a softball to my good friend Terry, with whom I've had many discussions on the alien tort statute. There are so many fascinating issues. And it's not, Terry, I don't want to take you on the question of whether the federal government can in fact file statements of interest based on foreign policy. That's clear that it can, but I don't want to debate that with you right now. So I've left the State Department, so that's a different thing. My question is more technical to you. I understand fully why foreign plaintiffs might want to bring their tort suits having nothing to do with the United States into U.S. courts. So you have the citizens of Zimbabwe suing Robert Mugabe for electoral violations and during the campaign, other violations, human rights in Zimbabwe, and one might say, well, what's this case doing in our court? So I can understand that. The question that I have for you is, what exactly is the jurisdictional basis for the constitutional basis for the Alien Tort Statute? It was written by the founders, by the people who wrote the Constitution, and it was in the jurisdictional section of the first Judiciary Act, so it must have been clear to them what the basis was. And the reason for the question is not abstract. It's very simple. Why is this statute necessary? Why isn't federal question jurisdiction altogether sufficient for purposes of suits in federal courts? There are different questions about jurisdiction in state courts, but what's your answer to that question?
You call that a softball, eh? Well, that debate has been raging. I think the best opinions on that are the Judge Bork decision in the Tel-Orin case out of the D.C. Circuit versus the majority decision in the Sousa case. And the question was simply, how did they do it at that time in 1789? Did they need a specific enabling statute, or was a grant of general jurisdiction sufficient because they tended to be reflecting more of a common law understanding in 1789? So I don't think there's a right answer. I think that right now we have a 6-3 decision that says that the position of the common law formation and the lack of a need for a specific enabling statute was sufficient to create a cause of action. But as you know, there have been several efforts, including fairly recently in the ABA on the international section, to try to come up with a statute that would in effect be an effective compromise between the corporate community and the plaintiffs and the victims and the human rights groups and so on. And I'm a proponent of that. I think that we really should have a bit more certainty and clarity on what are the issues that a company could be sued for, that would benefit them. They could make an effort to not do those things. And the circumstances under which you would face liability, that would be helpful to clarify. I don't think there's any chance at all that this will happen in the reasonably near future, but it is an exercise that at the end of the day I would like to engage in. So I don't think that completely answers your question, but I do think that there is a very legitimate debate out there on what should happen. One effort to solve it was the 1996 Torture Victims Protection Act, which was in many respects inadequate because it only dealt with two very narrow of the various norms that are possible out there under the law of nations.
Thanks. Okay, well, let's go ahead and take some questions. I think we've got one over here. Been waiting very patiently. Thank you.
I'd like for you to address domestic issues, if you don't mind. I have any number of, in state court, cases involving one or both parents who are not U.S. citizens with a child who is. And we get into all kind of issues with relocation, both with countries that are members of the Hague Convention and members are not. I've had one on every continent so far. Also have been asked to enforce a Bangladesh divorce decree when the Bangladesh couple went home on vacation and husband declared himself to be divorced and came back. So we're getting into lots of those issues. I just wanted to see how the new treaty might address those, or what other effect it might have on our domestic relations. Thank you.
The answer is clear. The new treaty doesn't address those. Family law issues are excluded, but it happens that we have an expert on international family law on the panel who is the best person in the world to answer the question about how they are covered.
Well, I talked about the Uniform Act, and I didn't talk about family law cases, but the issue of recognition and enforcement of those judgments really follows from the same principles. The Uniform Act technically applies to money judgments, but more generally, the same principles of comity will apply to divorce judgments, and the public policy exception in certain cases will be there. You have, of course, at least one treaty with respect to family law areas, and that's why you have the new support convention, which actually David knows more about the maintenance convention. But you have the Hague, and that may be the reference to the Hague Conference has done a number of treaties, and they have the very important treaty here, the Hague Convention on the Civil Aspects of Child Abduction, which means that if a child is taken from a country that is a party to the Hague Convention, the United States is under an obligation to return that child back to the country of habitual residence. And I think one of the important issues that has been raised in these international child abduction cases has been the question, the return is required when there is a custody right. And one of the questions is, if a parent has only visitation or access, but also there is a restriction on the party with custody from removing the child, what's known as a neexeat clause, is that a custody right? So there is a case now in the United States Supreme Court. The case, I think, is going to be argued next month. In that case, the left-behind father had access, and there was an order in the Chilean custody decree that said the mother shall not remove the child. Mother removed the child, and then the question was, should the child be returned? And the legal issue is, did the father, who had only access, which is not a custody right under the convention, but had this, there was also this restriction to stop the mother from taking the child out of the state, did that give him a custody right? And one of the interesting aspects of this case, as you said, you're interested in domestic issues, but here, of course, we have an international convention that has to be interpreted, and most other countries that have interpreted the convention have held that a right of access plus a restriction on removal of the child is a custody right within the meaning of the convention. There is a split in the circuits in the United States. The Supreme Court has taken it. So those of you interested in with family law cases, which I know you have, and the Hague abduction cases, many of those cases are in state court. They can be brought in federal court as well, one of the few areas. As well, I just should say one other thing. There is another convention that was negotiated at The Hague in 1996, which is a convention on jurisdiction and judgments in the area of custody jurisdiction. It's really, if you will, an international UCCJEA, and that is under consideration by the State Department as to whether or not the United States will join that convention. So there, in a whole host of areas, you see the influence of international law, if you will, infiltrating what have traditionally been, as you say, domestic issues in the state courts.
We're all familiar, or most of us probably are, from the publicity generated on the abduction of the children from, I guess it was New Jersey, and it appeared on NBC, and down to Brazil. And then the mother died in Brazil, and the father has been unable to get custody back from a member country to a Hague convention. And one is wondering whether or not there are teeth built into the new Hague Convention that is being considered for adoption by the U.S. Senate, when one member country fails to adhere to the provisions of the convention, whether or not there is an enforcement through the convention, through member states or member countries, or whether or not judges will be permitted to depart from a convention when it is clear and obvious on its face that a member country is not going to recognize it.
Well, just let me say one word about the Brazilian case, if I might. I mean, I know that case, and of course there's been a lot of criticism of Brazil and their failure to return the child. I should say that actually, with respect to the case I just mentioned, the Abbott case, where the United States has not wanted to return the child to Chile because it has an interpretation that's very different than what most countries have interpreted the Abduction Convention. There, the United States has been subject to criticism, and that entire question of who's abiding by a treaty when you need an international standard of interpretation. One of the problems, let me just say, with the Abduction Convention, I'm going to turn it to David to answer questions about the choice of court convention and what sanctions there are, if any. With respect to the Abduction Convention, countries that were members of the Hague Convention when the treaty was adopted the United States is obligated to ratify the treaty with respect to them. But with respect to other countries, the United States accedes to the convention with certain other countries which may not have, let's say, appropriate family law regimes. And initially, the United States wanted broad acceptance of the treaty, and so the United States took these accessions with respect to almost every country. Now they are looking very, very carefully, and they are deciding, for example, not to accept accessions to other countries that have joined the convention, and we say you don't have an appropriate court system or family law regime in place, and we are not acceding to the convention. There's nothing we can do with respect to members of the Hague Conference at the time the treaty was adopted, because that's a provision in the treaty itself. But I don't know, in the choice of court convention, David, I mean, what's the approach that's going to be used?
Well, for most of the Hague Convention, Hague Conference conventions, there's no judicial review. We're not party to a convention, for example, that says disputes to get taken to the International Court of Justice. The mechanism used by the Hague Conference is a review conference of states. So periodically, for example, they will convene a meeting of all the member states of the Service Convention, the Evidence Convention, or whatever, to discuss how it is being implemented. And in that context, criticisms are made. And they are mediated, if you will, and so on. But there's no mandatory consent. It's the way this is going to be done again, because it's a convention which will be applied by you. It's a convention that contemplates not implementation by the government, but decisions by courts in accordance with the terms of the convention. So inevitably there's going to be flex. There are going to be people who disagree with this judgment or that decision. And the way it's, quote, enforced is through discussion among states parties and adoption of text, interpretive texts.
Okay.
And this is
going to be the last one because we're running out of time here, so sorry.
And this is on the issue of the contractual forum selection clauses that would be enforced pursuant to this to be ratified, possibly, treaty. I know some states have, either by statute or case law, a recognition of contractual forum selection clauses, but usually that requires some nexus also to the state. Does this treaty recognize a nexus requirement or not? And then if not, I'm imagining circumstances where contracting parties with no nexus to a given forum will all necessarily likely choose that forum just because it has perhaps better, corporate contract law. And then that court would be overrun with lawsuits between parties who have no nexus at all to the state.
Excellent question, and you put your finger on one of the hot issues. The answer is the convention itself does not require a nexus. What it does do in Article 19 allows states parties to declare that their courts may refuse to determine disputes with respect to exclusive choice of court agreements if, except for the location of the chosen court, there's no connection between that state and the parties to the dispute. It's an opt-out. Where this really becomes relevant is in the case of those states where there are statutory or even constitutional requirements of some nexus. My understanding is there are some states in which there isn't such a requirement, but there are some in which there are. And if you think this through now, it becomes a rather difficult issue of jurisdiction. And to put it very starkly, and this is a somewhat contentious way of putting it, can the federal government, pursuant to a treaty mandate, that a state require its courts to take, or require the courts of a state directly to take a case that has no connection? Many people would say, no, we can't do that, even under the Supremacy Clause. Others would say, sure you can. I think the best way out is if the states resolve that issue for themselves. One way of looking at it is the question of subject matter jurisdiction. A party cannot change the subject matter of a court. You can waive your objections to personal jurisdiction, but you can't give a court subject matter jurisdiction it doesn't want to otherwise have. So if a state says, well, we don't want to take any cases that have, my favorite choice is Boise. I don't know if there's anybody here from there, but if Boise says we don't want to take a case between a Belgian and an Azerbaijani just because they want to come to Boise, so we'll make that our law, it's constitutional or whatever. Well, it seems to me then there is no jurisdiction and the treaty doesn't require it. But there's lots of dispute over this question. It's a good one and it's being discussed. I don't know the answer to it yet.
But the U.S. could take the reservation
We
if it
certainly
wanted
could.
to, and to make sure that this issue didn't arise with the tension between the states and the federal government.
We could, but in 15 seconds, let me give you the alternative. A U.S. party and another party in another country want to resolve their dispute in litigation. They're not going to choose the U.S. court. They're not going to choose the second. They want to choose a third country because it's neutral. They choose that because they don't want to go to arbitration. Now, the third country may say, well, you got nothing to do with us, so we're not going to take that case. Well, it seems to me for many transacting parties, it would be highly desirable to be able to take a case to Paris or London or wherever it is you want to go, even though it had no connection to the parties or the contract. So by taking the declaration, we may in fact undermine its utility to U.S. parties.
All right. Thank you to our panelists for laying out some really interesting issues, and let's give a round of applause.